Hi, I'm attorney Jeremy Huss. What is a Terry stop and frisk? The name comes from a 1968 United States Supreme Court case, Terry versus Ohio. A Terry stop, also known as a stop and frisk, and more formally as an investigatory stop, allows police to detain a person briefly. Because a Terry stop is a temporary restriction of a person's liberty, it is a seizure for Fourth Amendment purposes, so it naturally triggers some level of protection. A warrant is not required for a Terry stop and frisk, and the standard is not probable cause. Instead, a Terry stop is based on a reasonable, articulable suspicion that criminal activity is afoot. Simply put, this means that police are required to articulate specific facts supporting reasonable suspicion. If police can articulate specific facts supporting reasonable suspicion, they can approach and temporarily detain a person. During this encounter, police are justified to frisk or pat down or search the person for officer safety purposes. And if police locate any contraband or evidence during this pat-down, it may be used as evidence of a crime. Whether the police were justified in their suspicion comes down to the reasonableness of their suspicion, which comes down to perception and other possibilities. For this reason, it is important to retain a competent and experienced criminal defense attorney to review the articulated reasons police are required to show to initiate a Terry stop and frisk. Regardless of whether a person feels the police are justified in the Terry stop at the time is not relevant, and a person should cooperate by not resisting or preventing police from doing what they are deeming at the time is lawful. It is important to note here that in Arizona, a person is required to present their identification when law enforcement has belief a crime has occurred and has requested it. Always remain calm when dealing with the police, and never provide a statement and never consent to a search. The Terry investigatory detention will last as long as it takes police to dispel their suspicions. In determining whether the police acted appropriately, the court determines whether there was reasonable suspicion based on the totality of the circumstances, which includes an officer's training and experience level. If upon review of the facts and circumstances, it is determined the police basis for the stop and frisk was not justified, then a pretrial motion to suppress would need to be filed. Competent and experienced legal counsel is very important here to be able to properly identify and frame the specific issues. If the trial court agrees that the totality of the circumstances do not support reasonable suspicion, then any evidence obtained after the unlawful search and seizure would be suppressed as a fruit of the poisonous tree. To summarize, police may approach, detain, and frisk a person if the police can articulate reasonable suspicion. And this is based on a totality of the circumstances. If you enjoyed the content in this video, please like this video. And please leave me a comment in the comments section discussing your thoughts on police ability to stop and frisk a person. Also, please subscribe to my YouTube channel at Huss Law PLLC. Also, please leave me a comment if you would like to see a certain criminal law legal topic covered in these videos. And you can always call me to chit chat.